the criteria that I am obligated to consider, right, the three primary sentencing consideration, the galleon factors, one of which is the character of the defendant. That's why the state has presented this information. This information, though, it presents many more questions at times than answers, some of which we've already discussed. Including the fact that there is no postmark over the postage. There is what appears to be a stamp from the Waukesha County Jail. I'm now told, and I didn't, I guess, catch this during my review, is that envelope has a crease in it, whereas in all the other documents within it do not. There is information within that filing, as has been explained here today, where there's a verification that they are contemporaneous notes. Attorney Kukler indicated she recognized either her own or Attorney Galavise's handwriting on it, so there's some legitimacy as to how, or when I should say, that was part of this exhibit or this document was created, right, contemporaneously with the trial or during the trial. When I consider all of that, I think I am left with the inescapable and unenviable decision here today to make a finding that at a minimum there's a serious potential conflict of interest, perhaps even an actual conflict of interest. Looking at the authority in State versus Miller, this court must presume prejudice to Ms. Kurczewski in requiring her attorneys to represent her going further. She does not have an objection. I think there's an additional basis that there has now been a serious breakdown of communication and a difference of objectives between Ms. Kurczewski and her counsel, that this is a relationship that cannot be mended. And even though it means that this sentencing hearing must be adjourned and that new counsel be provided for Ms. Kurczewski, I am going to grant with reluctance, but I think it's the right thing to do, the motions to withdraw by attorneys Kukler and Galavise. Rather than reset a sentencing hearing today, knowing that this was a very lengthy trial for which transcripts may very well need to be obtained, and or new counsel review the live stream recordings that are available online of the trial itself, certainly talk with Ms. Kurczewski, maybe even talk with attorneys Kukler and Galavise at a minimum, get all discovery information from them. And last but not least, to give the state an opportunity to fully investigate this issue and present more accurate information to the court at the time of sentencing. I do believe it relates to a legitimate sentencing consideration, but as it states right now, this filing, I think, presents some more questions than answers, and I think more time also gives the state an opportunity. I have to be mindful that both sides have the right to a fair hearing.
You know, I would really agree with this judge when she says this filing, this 37-page letter that it's being investigated, presents more questions than answers at this moment in time. Still with us, Attorney Chrisanne Hall. Weigh in on that, Chrisanne, because it's true they're investigating, but there are a lot of unknowns still at this point.
You know, what really struck me is in some time ago in the judge's inquiry, she said to the state, you know, there seems to be a lot of supposition on your part around this letter. This seems to be an allegation that she wrote this letter. She denies, but there's no proof that you know that she wrote this letter. And I thought what was really telling from the state side as well is the prosecutor said, well, I'm no handwriting expert, but it looks similar enough to me, and then listed off a bunch of circumstantial evidence. I was thinking to myself at the time, I'm like, yeah, it's right. You're not a handwriting expert. And this document opens more questions, as the judge has said, than it does give any answers.
You're right, Chrisanne, and we know it's going to be appealed. So I would think the state would also want to investigate to see what is discovered before actually going forward on sentencing. Okay,
right.
Let's just recap and have you comment on the judge's ruling. She said she did find at a minimum the serious potential of a conflict of interest, that therefore under the law you have to presume, she must presume prejudice to Ms. Kurczewski, and the additional basis that relationship between Ms. Kurczewski and her attorneys has certainly deteriorated. She had no objection to the attorneys withdrawing, and therefore she granted these motions. These two attorneys are off the case for sentencing, although the judge did it with reluctance. What do you think?
You know, I think once the attorney told her that the Bar Association said he had to withdraw, I'm not quite sure she had much else that she could do in that. And the one thing that I really take away from this was just how articulate Ms. Kurczewski was. She was calm. She was frustrated, obviously, and I think the judge really sympathized with her frustration. She's like, I've been a week without legal counsel. How can I be stuck here without any legal counsel? So the judge really had to wrap this up today, if anything, knowing it's going to appeal, that the defendant has a right to have counsel.
Yeah, and I agree with you. She was so articulate and well-spoken, frustrated, who wouldn't be? But I also have to say, all I could think when she says, I didn't write it, I didn't write it. I hope for her sake that that's the truth. Otherwise, I think that's going to bite her. All right, thank you.